who sits to my right, and my learned friends, Mr. Solomon, King's Counsel, and Mr. Sanders, appear for the respondents on this appeal. My Lords, the proceedings below, which have generated this appeal, had their ultimate origin in a sale and purchase agreement dated the 24th of March 2022. That, of course, is in your Lordship's bundle and has been referred to at various stages in the skeleton arguments, and I don't propose, unless your Lordships would like me to take you to it at the moment. Suffice to say that under that SPA, the second claimant and the second appellant, Athena as I'll describe it, contracted with the first and third defendants, who are husband and wife, to acquire 100% of the share capital in C1, my other client, Derma Med. Hence, at that stage, C2 became C1's parent company. And my Lord, after the completion of the purchases, it was a term of the various arrangements that Ds 1 and 3, Dr. Ali and his wife, would remain as employees of C1, Derma Med, and directors of C1. And specifically from the point of view of D1, Dr. Ali, that was important to the buying parties because Dr. Ali is a very well-known and very well-regarded, as I understand it, figure within the particular industry in which Derma Med trades and had a large reputation, and it was important that he remained the face and figurehead of Derma Med, at least for a period of time. And my Lords may have seen, and I don't propose to go through the SPA in any detail, my Lords may have seen that under that SPA, Dr. Ali and his wife D3 received very substantial payments. I shall come back to that in due course. And in return for those payments, they first of all sold their shareholding in D1, but secondly entered into various covenants of a conventional form within the SPA, and particularly, your Lordships will have seen they entered into a non-compete covenant at clause 13.1 in relatively conventional form, and an obligation not to misuse C1's confidential information. That's at clause 12, and of course those two clauses are to some extent at the heart of this case. Now, my Lords, we have in our skeleton argument set out the history of events that occurred from March 2022 through to May and June 2023, and I don't propose to trouble the court any further or rehearse those facts with your Lordships today. The next thing that happens of importance, my Lords, is that on the 22nd of June 2023, my two clients, the first and second appellants, made an application or came before Mr. Justice Constable ex parte to seek various relief. And your Lordships may have seen that there were, the claim form was issued on the 21st of June, I believe, and Mr. Siddle, King's Counsel, who appeared below, had prepared a skeleton argument, a long skeleton argument in your Lordship's bundle, and there were two affidavits sworn, I think, on the 20th of June in support of the injunctive and other relief that was sought ex parte. And your Lordships may have seen that the application that was brought before Mr. Justice Constable in the King's Bench Division on that day was founded on my client's strong suspicion that, notwithstanding Dr. Ali's contractual commitments and indeed fiduciary obligations in his capacity as a director and employee of C1, that he had diverted business away from the company, from C1, was unlawfully competing with Derma Med, and was not accounting to C1, Derma Med, his employer, and the company of which he was a director, for treatments he had carried out. In essence, my Lords, part of the case and part of the suspicions that brought and prompted the case was that Dr. Ali was stealing money, to put it bluntly. Now, your Lordships may have seen that the relief that was sought was in various forms. Injunctions were sought, and preservation and imaging orders were sought as well, and disclosure orders were sought. And my Lords, the application came before, as I say, Mr. Justice Constable, and Mr. Siddle, King's Counsel, presented the case on the 22nd of June on a without notice basis. And your lordships have the skeleton argument in the bundle. I don't propose to take your lordships to it now. Your lordships have a transcript of the hearing. It's not a transcript in the full sense, but it's a full note that was taken by Mr. Siddle's solicitors on that occasion. And what we don't know from that, my lords, is that the hearing before the learned judge on the 22nd of June lasted some considerable time. The hearing started, I believe, at 10:30 a.m. The judge then rose for the short adjournment. He came back into court. He actually delivered, as I understand it, a written judgment that he prepared over the short adjournment, and perhaps he'd started work on it beforehand, I don't know. And the hearing finally ended.
Morning hearing, according to the note, finished at 12:10.
12:10, and he reserved judgment.
He gave judgment at 2:30.
That's right. I think yes, that's right. So it's not, as one experiences sometimes. It wasn't a hearing where one comes in and the relief is discussed for a matter of minutes, and then it's granted. There were clear interchanges between the judge and counsel, and the judge, as the transcript or the note demonstrates, asked questions of Mr. Siddle and posed issues to him. And my lords, we have a fully reasoned written judgment from Mr. Justice Constable, which is in the supplemental bundle at tab 5. And what we can glean from that, I don't propose to show your lordships it now, from that is that the learned judge was persuaded to grant the bulk of the relief that was sought. The only relief he declined to grant on an ex parte basis was the application for disclosure of bank statements, and that we see that at paragraph 37 of the bundle of his judgment. Sorry. Now, it's I think appropriate to look at, if your lordships would care to, the order that Mr. Justice Constable was persuaded to make on that occasion. We find that at tab 4 of the supplemental bundle, page 74, and your lordships will see that is an order dated and stamped, sealed on the 22nd of June. If we go over the page to page 75, my lords will see that the return date was fixed for the 24th of July. That's paragraph 3. The first injunction is at paragraph 4, which is an injunction as regards the non-competition. That's paragraph 4. And then paragraph 5, my lords, is the injunction as regards confidential information. And your lordships will see will keep confidential all confidential information, paragraph 5. And that, of course, is a defined term. And if perhaps we can just turn, if your lordships would care to bundle to Schedule B, you see at page 81 the definition of confidential information. And your lordships will see that it is headed all confidential or proprietary information, and the bracketed words, including but not limited to, and then little 1 and little 2. And my lords, that definition, which has been criticised, and I will come back to that, of course, was drawn from the precise words of the SPA. My lords, if I can invite your lordships to go back to page 76, your lordships will see that, therefore, we're back at paragraph 5, that's the confidentiality injunction. There's then a suite of injunctions, or orders, I should say, at paragraph 6 through to 8, which are, broadly speaking, ancillary to the order at paragraph 9, page 77, which is the order requiring Dr. Alley to attend the premises of an independent IT expert, some individuals from Kroll, to deliver up their devices. And that's paragraph 9, which is again in broadly conventional form, although of course it's not an order granted every day of the week. I accept that. My lords, paragraph 11 was the order for delivery up of account statements in respect of any account held by either of them with Zettel or by PayPad. My lords, your lordships may know what Zettel is, but it's a form of card reader which is used, I mean, one sees it in taxi cabs and in shops and what have you. It's a way of receiving payment in a relatively simple and convenient way. And my lords, your lordships may have seen that the reason and rationale behind paragraph 11 was the fear and suspicion that Dr. Ali had obtained or purchased a Zettel card reader in the days leading up to the completion of the SPA, and had then been using that card reader to obtain payment from patients or clients to his own personal account held by D2, Zak Ali Limited, his company, rather than for the purposes or benefit of his employer, Derma Med. And my lords, finally, your lordships will see the adjournment of the other application at paragraph 12. And my lords, before I leave this order, can I just finally show your lordships the undertakings at page 80, which are given by the first and second applicants, i.e. the totality of the claimants, and an issue has arisen, as your lordships may have seen on my learned friend's skeleton argument, about the width of the cross undertakings. But the undertakings were in conventional form, but given by applicant 1 and applicant 2. My lord, that's the order of Mr. Justice Constable. The defendants were then served with the material the next day, and on the 27th of June, my clients issued the conventional application to continue the injunctions post the return date. I don't take your lordships to that, but it's for your lordships' note. It's a tab 6, page 98 of the supplemental bundle. And again, without wishing to trouble your lordships with the actual document, which is in conventional form, that was an application notice seeking continuation of the non-compete and confidentiality injunctions, and it sought a variety of other relief, which potentially followed on from the imaging order that had been made. And the imaging order was indeed made, my lord, because Miss Dr. Ali, in accordance with the order, delivered up certain devices shortly after it was served, I think on the 26th of June of last year. There was an issue about whether he delivered up all his devices, capital D devices, and it turned out he hadn't. I don't want to make a huge issue of that now. There was some debate about that, and in fact Dr. Ali put in an affidavit, his first affidavit, which was, I think, dated the 30th of June, so very shortly after the order had been made, explaining why he had not delivered up all his devices. The other ones were shortly thereafter delivered up, and also explaining why he had deleted certain messages and appointments on his devices with clients or patients, we say, which he was unlawfully treating when they should have been treated by my client, Derma Med. My lord, the other event that occurred on the 30th of June, which is significant for this appeal, is that my learned friend's solicitors, Dr. Ali's solicitors, DWF, wrote a letter on the 30th of June, and that's a letter which, for your lordship's note, is at tab 47, page 681 of the supplemental bundle, complaining about certain alleged non-disclosures and breaches of the full and frank disclosure duty at the hearing on the 22nd of June. And my lords, obviously I will have to address the gravamen of those complaints as they were subsequently articulated in the witness statement and skeleton argument. But for the purposes of my chronology, it's significant to mention this, I suggest respectfully, that DWF, acting for Dr. Ali and all the defendants, but particularly Dr. Ali for these purposes, identified no other ground for suggesting that the orders that were made had been wrongly made. The criticisms were confined to certain alleged breaches of the duty of full and frank disclosure. And my lords, what then happened, your lordships will recall that the return date has been fixed for the 24th of July. What then happened on the 18th of July is that the defendants issued an application to set aside the injunctions. And I do ask your lordships, please, just to turn to that very briefly. It's at tab 8, page 127 of the supplemental bundle. That's my learned friend's client's application notice of the 18th of July, so issued a few days before the return date. And your lordships will see in box 3 the order that was being sought by my learned friend's clients. And your lordships will see that the foundation for the setting aside of the injunctions granted by Mr. Justice Constable were squarely placed on under the rubric material non-disclosure. And then there were another application for delivery of the particulars of claim, which I don't think I need to trouble your lordships with. Now, my lords, on the same day as that application notice was issued, Dr. Ali put in his witness statement, his second witness statement. And I should say for clarity, there is no first witness statement. What Dr. Ali did, perfectly understandably, was decide to use number 2 because he produced an affidavit 3 weeks or so earlier. So there's no witness statement number 1, that's the affidavit. And my lord, that is a long witness statement that Dr. Ali prepared. I'm not going to take your lordships to it, but it's at tab 18, page 382 of the bundle. And it set out a long and detailed account of what he said the history was of the relationship between the parties. It made various complaints. And there was a special section, a separate section in that witness statement, which set out Dr. Ali's complaints relating to full and frank disclosure. And again, of course, I will come back to that. It also contains certain admissions, which I shall also come back to in short order. My lords, the return date was fixed. In fact, I noticed from page 127 it was fixed for the 25th of July. Doesn't matter. But in advance of the return date, the parties entered into certain without prejudice negotiations for the purposes of adjourning the return date. And what we know, and all that your lordships need to know, is that the parties agreed a consent order on the 23rd of July. My lords, I do ask your lordships to look at that very briefly. It's at tab 7 of the supplemental bundle. And we see the bulk of it at page 123, where what is ordered by consent is that the return date shall be adjourned over to the first available date after the 12th of September 2023, and that in the event became the 17th of October, as I'll come on to. The injunctions were continued, paragraph 2, and the defendants actually agreed by consent to provide their bank statements for an extended period of time, a rather longer time than that which had been sought, I think, by the original application notice. That's paragraph 3. And then there were other paragraphs which of a more adjectival nature at 4, 5, 6, and 7. My lords, rather, there was an undertaking given by Dr. Ali at page 125 to hold £2 million in a particular account until the return date. And there was also an undertaking, perhaps rather strangely, or unusually rather, at page 126, whereby the defendants undertook to mediate. That's page 126. My lords, the outcome of that was that those bank statements, as ordered by consent, were delivered. There was a mediation, and the mediation was unsuccessful. And that's all your lordships need to know, of course, about that. But what I want to pause at now is to show your lordships what emerged from the disclosure and the witness statement that Dr. Ali provided. Your lordships will recall that 2 sets of disclosure were provided pursuant to the orders of the court. The Zettel card payments pursuant to the Constable J order, and the bank statements pursuant to the consent order. And the third piece of evidence that emerged was Dr. Ali's own second witness statement. And what, taken together, that evidence and disclosure showed as regards the underlying merits of the application and the underlying merits of the suspicions that had actuated the claimants into issuing their application in the first place was startling, I respectfully suggest. What it showed, my lords, is that the suspicions of the claimants were entirely vindicated, and serious wrongdoing was not only disclosed, but admitted by Dr. Ali. And what I would like to do now, if I may, is show your lordships that by reference to Dr. Ali's own words. And that involves picking up the supplemental bundle at tab 18, please. And that's the long witness statement of Dr. Ali, dated the 18th of July, that I've mentioned. And I'm only going to show your lordship a small part of it. And in particular, pages 424. Well, we start at page 424 if that's convenient, my lord. This is right at the end. Now, what emerges from 424, and in particular paragraphs 73 and 74, is the following. An admission by Dr. Ali that during the period from 24th of March 2022 onwards, i.e. the very day of the completion of the SPA completing, until the beginning of June 2023, so a period of 15 months, on his own admission, Dr. Ali had obtained £188,000 plus by engaging in illicit competitive activity and diversion of clients. And that 188,000 was divided up or broken down into payments via Zettel card reader, payments via personal bank transfer, and payments, remarkably, your lordships may think, by actual cash being handed over by my clients' directly to Dr. Ali, thereby effectively depriving my clients of monies that they were due. And we would suggest that is no less and no more than theft. And it's admitted, paragraph 73, over to paragraph 74. We see the 188,000 figure. Now, my lords, by way of parenthesis, we don't for one moment accept on this side of the court that 188,000 is the true figure, but it is the minimum figure because it is admitted by Dr. Ali. And indeed, analysis by Mr. Terry, one of my client's witnesses, and I don't take your lordships to the detail of it, by Mr. Terry, suggests that in fact the true figure is in excess of £219,000. But of course, your lordships can come to know, and I don't invite your lordships to come to any final conclusion on that now. The other aspect of this, again, which is, as I understand it, admitted, is that certain of those payments were taken on Zettel via the Zettel card reader in respect of patients seen by Dr. Ali in my client's premises and using my client's equipment and material. And of course, Botox, as I believe it's called, requires material, filler. So the remarkable fact that emerges is that Dr. Ali treated my client's patients and then produced his Zettel card reader and said, would you mind paying this way rather than any other way? And that went straight into his company's bank account. And we say that's theft on this side of the court. And my lord, that illicit and dishonest activity, as we characterise it, is to be contrasted with what Dr. Ali caused his solicitors to write to us when we first started demonstrating suspicions about this. When we wrote, Dr. Ali caused DWF to write a letter to my client saying that their suspicions were no less than, and this is the word they used, paranoia. And for your lordship's note, that's supplemental bundle, tab 46, page 677, paragraph 8 of a letter dated the 16th of June 2023. So Dr. Ali caused his solicitors, utterly unwittingly of course, to lie to my clients, to tell them they were being paranoid. In fact, they weren't being paranoid, they were entirely correct. My lords, the admissions went further. I ask your lordships now to turn to page 415 of the same tab. We're now in a landscape part of the witness statement. And at page 415, one sees little 6, where Dr. Ali admitted that he had a Zettel card terminal linked to his own company's bank account. Your Lordship will see that in the paragraph 6 of the landscape at page 415. And then down the page at 417, the third paragraph of the big section, the big box, following the so-called October reset, and Your Lordships will have seen that in my skeleton argument, what that was about. I did continue to provide, and then the euphemistic phrase, off-book treatments, taking payments directly from patients and not accounting to Derma Med for the same. And I do recall I saw certain patients, and I provided approximately treatments to 68 patients following the October reset, says Dr. Ali. So he accepts and admits that he actually did have his own special, separate Zettel card reader. My Lords, turning the page to 417, please. We see what Your Lordships might think is the remarkable and candid admission. This is at box 8, and we're in the bigger box of section 8. In the second paragraph, we see, this is halfway down the page, there may have been a handful of occasions where I took cash payments from some patients under the pretext that the Derma medical Zettel card payment was not working. Just pause there, my Lords, just think about what the implications of that is. A patient comes along to my client's clinic, or as my client's client, Derma Med's client, thinking it's being treated. And Dr. Ali, in order to avoid my clients getting the benefit of that work, lies to them by saying, sorry, the Derma Med Zettel card payment terminal's not working. But if you could just hand me £1,000, that would be just fine. My Lords, that is tantamount, the analogy that springs to mind is a partner in a solicitor's firm receives a client in the firm's offices, gives advice to that client, and when the client says, well, how much do I owe you? Says, oh, actually, you can't pay the firm because their payment systems are down. Just pay me the £3,000 for this consultation, or what it might be, in cash. And that's just theft, my Lord. No, nothing more and nothing less.
Seems odd that he said there may have been. You'd think he'd know one way or the other.
Well, you'd have thought so, my Lord, quite. I think that's a bit of sotto voce. I mean, it's fair to say that the entire tenor of the way that Dr. Ali's responded to these allegations, and my learned friend below, was to say, well, you've committed breaches, we've committed breaches, all's fair in love and war. We take a rather different view of that, and it may be Your Lordships will as well. Of course, it's a matter for Your Lordships. The next admission, my Lord, is at page 418, where he admits, and I'm having to go through this quite quickly, of course, my Lords. He admits at box 10 that he changed the email address on the ZA account. And again, I don't want to go into this in too much detail. Your Lordships may have seen something about this. But the Instagram account is the window to the world for Derma Med. And there's Dr. Ali, this very well-known, highly respected man in this field, issuing posts and about all the great work he's doing. And no doubt he is doing great work. And nothing I'd say is intended to detract from that. It's the shop front to the world, as it's been described in the evidence. And there's an email address at the bottom of it saying, if you want to have some of these amazing treatments, send the email to a Derma Med account. And what Dr. Ali did after some suspicions were being articulated back in September, was he changed the email account so it went personally to him. So that all inquiries about, I'd love to have some work done by Derma Med went to zachalli@doctors.org.uk. Remarkable, one might think. He then admits at page 422, this is further on, that notwithstanding the contract, the SPA requires all inquiries made to him for Derma Med work to be passed on to a certain Dr. Mr. Woods, who's one of the employees of the group that owns Derma Med. He never did so. And he never did so, my Lords, because he didn't want to direct inquiries to my client, because he wanted to do the work himself and charge the work for himself. And notwithstanding he'd received millions and millions of pounds under the SPA, not content with the 5 million up front, the forgiveness of another 5 million, and various other payments I'll come on to. Not content with that, my lords, he was deciding to divert hundreds of thousands of pounds, we suspect, into his back pocket. He admits also, page 420, I'm sorry, I'm going back in time, I'm so sorry for that. At 420, that he deleted direct messages on the ZA account. And again, I don't want to get into the technicality of this, I don't have time. But your lordships may be aware that under Instagram you can send DMs, as they're proverbially known, so as I understand it. And he deleted them, and we've got evidence, which has not been contradicted in any meaningful way, that messages would appear. They looked like they were work-related or business-related, and then within seconds they were deleted. And we suspect, and we will more than suspect, that was so that the prying eyes of Derma Med would be kept away from Dr. Ali's illicit activities. But he admits the deletions at page 420. And he admits, as I say, at page 421 to 422, that contrary to his obligations, contractual and fiduciary, he did not refer all treatments requests to his employer. My lord, I'm going to say no more about that. But what I do say is that my learned friends have said a lot in their skeleton argument about a lot of matters. And my learned friends are not backward in coming forward, so to speak, when it comes to dismissing submissions that I have made. And I've seen that some of my submissions are characterised as absurd. And my learned friends, of course, can say what they like about my submissions, and no doubt will make submissions about it. But what is missing, and remarkably missing, you might think, from my learned friend's skeleton argument, is any engagement with those key facts. My learned friend Mr. Kinlan and myself felt able, consistent with our professional obligations, to characterise in the skeleton argument for which permission was appeal was granted, to characterise Dr. Ali's admitted conduct as, I quote, a covert and dishonest course of conduct. Now, if that was thought to be an improper or unfair characterisation of Dr. Ali's behaviour, then one can be absolutely certain that Mr. Solomon, whose reputation stands before him, would have articulated his dissent and dissatisfaction in his skeleton argument. He says literally nothing about what we choose to characterise as Dr. Ali's dishonesty. And that's because there can be no doubt that what was revealed by this application, by the Zettel card reader statements, was dishonesty on a grand scale. And as your lordships will know, we say that that was a highly material factor. I'm not going to make the submission now. When the matter came before Mr. Justice Bourne and was essentially ignored by the learned judge below. Now, my lords, I move on. The return date, as your lordships know, was the 17th of October 2023. And on that occasion, Mr. Siddle was joined by Mr. Mathewson as his junior, and the representation for the defendants was my learned friend Mr. Solomon and Mr. Sanders. Skeleton arguments were served and exchanged on the Friday before the Tuesday. That's the 13th of October. Your lordships have those skeleton arguments in the bundle. I don't propose to take them, your lordships, to them. Maybe I have to show your lordships a couple of paragraphs at some stage. They were lodged on the Friday. And what was absolutely clear from my learned friend Mr. Solomon's skeleton was that the sole foundation for their application to set aside the orders that were made by Mr. Justice Constable was breach of the duty of full and frank disclosure. And that's paragraph 4 of my learned friend's skeleton argument at the return date, page 179 of the supplemental bundle. Not suggested that they were improperly granted for any other reason, that the American Cyanamid test had not been met or anything like that. Purely full and frank disclosure. Now, the point was also taken for the first time in the skeleton argument of my learned friends on the 13th of October, that Mr. Siddle had been at fault, and his clients therefore had been at fault, for seeking a confidentiality injunction in too wide a term. And I'm going to come to this, of course, in detail. but it's important to recognise by reference to the chronology that that was the first occasion, so days before the return date hearing, the first occasion that the defendants had chosen to characterise that as a breach of the duty of full and frank disclosure. It is right to say, as I will show your lordships, that there had been some complaint about the width of the confidentiality injunctions, but not in any shape or form as a full and frank disclosure breach. And the response of my clients to receiving Mr. Solomon's skeleton argument and seeing for the first time the suggestion that the confidentiality injunction itself constituted a breach of the full and frank disclosure obligation, my solicitors wrote back on the Friday morning, on the Tuesday morning, I should say, before the hearing, to say, well, if you're complaining about this being too wide, here's a narrower form of injunction, and that is, for your lordship's note, a letter at tab 50, page 696. I'll come on to that in due course, because it's relevant to the confidentiality aspect of this claim. Now, my lords, the transcript of the argument on that date is at tab 13, page 238. I possibly may dip into it from time to time, but that's where it is, tab 13, page 238. And it was a full day of argument for Mr. Justice Bourne. And your lordships may recall that Mr. Justice Bourne then, at about 4 p.m. or so, retired for a few minutes to consider his judgment, rose to consider his judgment, and then came back and delivered the judgment, which is at tab 6 of the core bundle, which I'm sure your lordships will have read. It's a short judgment delivered orally. Now, my lords, if we can go to the core bundle, I'm going to show your lordships the two orders that flowed from that judgment. The first, my lord, is at tab 5. We're now on the, I do apologise, tab 4. And this is page 45 of the core bundle. And this was an order that was made on the 17th of October itself. And by it, all the injunctions were discharged. It was ordered that the forensic images be retained, but otherwise no further order was made on the continuation application, and orders were made as to cost submissions. My lord, just while we're here, can I just invite your lordships to turn to the top of page 46. This is the first order of Mr. Justice Bourne of the 17th of October, flowing from his judgment whereby he dismissed the application of my clients and upheld my learned friend Mr. Solomon's cross-application. But your lordships will see there that the court did accept an undertaking from PCPF, that is the parent company of C2. And that the relevance of that I'll come on to in due course. So, my lords, that's the first order, which was effectively defeat for the claimants and success for the defendants, albeit there was some, the forensic images were retained by the IT expert. My lord, what then happened was, pursuant to the court's order, there were submissions on costs made in writing. Those submissions then led to the second order of Mr. Justice Bourne, tab 5, page 47, where the order of the court was that the claimants will pay, this is paragraph 1, the defendant's costs of the applications, and the applications was a defined term, that was all the applications, including the ex parte application on the 20th, to be the subject of detailed assessment. An interim payment was ordered, paragraph 2, £110,000, that has been paid, I should say, by my clients, and permission to appeal was refused. And then there was, the reasons were then set out on the face of the order. And my lord, the most important paragraph as regards costs is paragraph 3, page 48. And if I can just, it's a very short paragraph, if I can just invite the court just to cast an eye over paragraph 3 if you haven't done so already. Now the consequence, well, your lordship will see that it was the supposed, or as the court characterised it, fundamental failure to make full and frank disclosure that effectively led to an order which had very, very serious cash consequences for my clients. your lordships have got in the bundle, I don't going to take your lordships to them, cost schedules that were served by both sides below, as regards all stages of the proceedings. My clients have spent a very substantial sum of money at the ex parte application, and that was because they had to put in a very two long affidavits setting out what they suspected Dr. Ali of doing. And of course, your lordships will know that ex parte applications, and indeed any form of application seeking the kind of relief that was sought, are long and difficult things to get together. And of course, there was then a full-blown return date, there was the consent order, and there was a good deal of further evidence served by my clients to make good various aspects of their substantive claim. And the costs that they incurred below were nigh on £500,000. The costs that my learned friends had incurred below were nigh on, or just more than, £220,000 inclusive of that. So the costs that were incurred at the first instance proceedings, ex parte and inter partes, in total are in excess of £700,000. Now, the effect of the court's order of the 17th of November, which flowed in part from the order of the 17th of October, 7th of November, 17th of October, was that my clients will forever be shut out from ever getting back 1 penny of their costs, and are forever liable to the defendants for the totality of their costs. So to put it in perspective, the costs that were expended by Dr. Ali in setting out the admissions in his witness statement, which we've looked at just a few minutes ago, are costs my clients have to pay forever, unless this court intervenes. My lords, the final stage of the proceedings below is that my clients served, pursuant to the court's order, their particulars of claim on the 28th of November. That's the particulars of claim in the underlying proceedings. Your lordships will see that we sought on the same day permission to appeal. By this stage, myself and my learned friend Mr. Kidman had been instructed in place of Mr. Siddle and Mr. Mathewson, and your lordships will see that we made an application for expedition for obvious reasons. That came before Lady Justice Elizabeth Lang on the 4th of December, so very quickly, and the learned Lady Justice gave permission. Your lordships will have seen that that is at tab 9 of the core bundle, and she ordered that this hearing be expedited, and this was the earliest available date, today the 30th of January, which is why we are here before your lordships today. The final piece in the jigsaw before coming to the substance of the matter, my lords, is my learned friend's respondent's notice, which is at tab 11 of the core bundle, where my learned friends seek to uphold the learned judge's judgment below on one further ground, and that is at page 112 of the core bundle. And that is that the judge had erred at paragraph 26 of his judgment in holding that there was a serious issue to be tried between the parties as to whether or not the SPA had been validly terminated by the respondents. So essentially what is being said by my learned friends, as I understand it, is that the judge below and your lordships today should hold that in fact it's so blindingly obvious that the matter can be dealt with now that my clients were in repudiatory breach of the SPA, and that repudiatory breach was validly accepted on the 12th of July. And perhaps I should have told your lordships that shortly in that period between the ex parte hearing and the first return date, Dr. Ali purported, in fact his wife as well, purported to accept a repudiatory breach on the part, alleged repudiatory breach on the part of my clients. My lords, I'll come back to that. I now turn, if I may, to the grounds of appeal. Your lordship will see
just before you do that, Mr. Grant, is the position that the proceedings at first instance have gone no further. There's been particulars of claim.
Yes, my lord.
No defence, no directions for trial, and something like £1 million spent up to today, and in theory a massive trial to come.
My lord, the position is as follows. The defence was due, I believe, in December, late December. A request was made to extend time for the service of defence, which was acceded to. there is now further debate about when the defence should be due. I think it was then meant to be due last week, and then a further extension has been sought. And I don't want to go into the reasons why. In one sense, it would take too much time. But the defence is due relatively imminently. But at the moment, the precise date for service of the defence is a contentious question, whether it's now or later on this week or in one or 2 weeks' time. So the defence is on the verge of being served, but it hasn't been served. There have been no directions, my lord, but because the pleadings are not closed yet, towards the trial. My lord raises one interesting question, and a fair one, if I may respectfully say. There was a debate before Mr. Justice Bourne about the question of speedy trial, and the claimants, Mr. Siddle, was saying, look, we are perfectly content to have a speedy trial, so as to avoid the question of the non-compete injunction sort of expiring before it can be considered. So Mr. Siddle was perfectly content to suggest a speedy trial in January, so i.e. earlier this month. Mr. Solomon resisted that and said they don't want a speedy trial. The defendants did not want a speedy trial. And one of the grounds on which he resisted it, my lord, was which I'm going to come on to, it's an interesting aspect of this case, is because he said that Dr. Ali, notwithstanding he'd apparently accepted a repudiatory breach on the part of my clients, he didn't want to, he had no intention of competing. Now, if you had no intention of competing, which is in itself a moot question, which I'll come on to, that presumably fortified well, I don't need a speedy trial, so I don't need to work out whether I can or can't compete. So, my lord, I hope that's an adequate answer to your lordship's question. But there is nothing, but I've been instructed for a relatively short period of time. I was instructed in November with my learned friend Mr. Kinman to produce the papers for the appeal, to draft and finalise the particulars of claim, and that occurred basically 2 months ago. Nothing has happened since that time other than intensive preparation for this appeal and some procedural argy-bargy concerning defence. That's the answer.
Thank you.
Thank you. My lords, I now turn to the grounds of appeal, and your lordships will have seen my grounds, my appellant's notice rather, is at tab 1 of the court article, and the grounds are at page 14, and they are divided into 4. And the first is what we respectfully say is that the judge below erred in his characterisation of the supposed breaches by my clients at the ex parte hearing on the 22nd of June. And we've expatiated on that in our skeleton argument. And what I want to do now is go through each of the grounds, or rather each of the bases on which the judge condemned my client. And my lord, that involves looking to tab 6, Mr. Justice Bourne's judgment, paragraph 18, please, page 58. So the first head of full and frank disclosure breach, if I can use that shorthand, is addressed at paragraphs 18 and 19 of the judgment below. And that was the decision on the part of the claimants to proceed ex parte, not as regards the imaging order and the ancillary orders relating to the imaging order, but as regards the non-compete injunction. And what the judge decided, persuaded by my learned friend Mr. Solomon, was that that particular aspect of the relief did not need to be and should not have been sought ex parte, but should have been sought inter partes. And my lord, I want to set out some facts about this case, against which one can characterise the strength or weakness of Mr. Solomon's argument and the justice of Mr. Justice Bourne's decision. And the following facts are pertinent. 1, Mr. Justice Constable at the ex parte hearing was absolutely clear about what the law of ex parte or without notice applications was. And he set it out at length in his judgment. And to make good that point, may I please pick up supplemental bundle tab 5. That's the judgment of Mr. Justice Constable. And if we turn to paragraph 13, which is page 90, we see that the learned judge below, at the ex parte hearing, cites the relevant parts of CPR Part 25. He cites the Chancery Guide on the question of when it's appropriate to go ex parte. He cites the famous decision of Lord Justice Brooke in Moat Housing. My lords, the reason he cited those decisions and that learning that decision and that learning was because Mr. Siddle, in his skeleton argument, had been punctilious about addressing the court on the law without notice. And to make good that point, please turn to tab 2 of the supplemental bundle, which is Mr. Siddle's ex parte skeleton, and particularly page 30. Where he'd set out what orders were being sought without notice. That's paragraph 7. Totally clear. And then page 32, which is tab 2 of the supplemental bundle, Mr. Siddle's skeleton argument. I'm sorry, 33, tab 12, a paragraph 12, where the reasons are set out and cross-referred to the witness statement of Mr. Terry, which I'm going to come on to. And then we see the reference to the Chancery Guide and the reference to Part 25. And your Lordship will see, because it's a point my learned friend is exercised by, a quotation from Brearley and Block on employee covenants. And I'm going to address that point in due course. So, the court below, and then if we go over the page, I'm so sorry, we should go over the page 34, the reference to Moat Housing, the reference to Bates and Lord Hailsham, and the reference to Memory Corporation and Civil over at paragraph 35, page 35, I'm so sorry. The famous dictum about the duty of full and frank disclosure. And then paragraph 22, the obligation to draw the court's attention to adverse material. Secretary has been said many times, of course, that's one example of that decision. And in fact, if we then go to further down the page, further down the skeleton to page 52, and 53 rather, Mr. Siddle sets out a number of grounds on which the court might want to decline the relief. And I'm not proposing to go into them now, but what it shows, in my respectful submission, is that Mr. Siddle was punctilious. He may have got some things wrong, and I'm going to accept that. He accepted that before Mr. Justice Bourne. But they were of a minor nature, I'm going to suggest. But what I do want to suggest to your Lordship is that Mr. Siddle, barrister of long standing, King's Counsel since 2019, a barrister of entirely integrity. He may have made a mistake, I accept that, but the point I want to make is that this is not some fly-by-night cavalier application by a fly-by-night barrister. And my learned friend knows that better than anyone in this court, because they're James' colleagues. Mr. Siddle is, as far as I understand, his reputation is very high.
Let's try and keep personality out of Mr.
Yes.
Grant. What mistake do you accept that Mr.
The
Siddle
mistake
made?
that I accept he made is the mistake that he himself conceded as regards the width of the confidentiality agreement, which I'm going to come on to, my lord.
It isn't another mistake. He shouldn't actually have applied without notice at all, because on reflection, there was no good reason for applying without notice.
Well, my lord, I'm going to address
material non-disclosure. It may have been a mistake, but it shouldn't have happened.
Well, my lord, I'm going to address that point head on, if I may, which is what the submission I was seeking to make was that, first of all, this was not a cavalier application, and this was an application which had been put together with some care. There was a very long skeleton, there were very long affidavits, and there was a long period of time in court. The court was addressed on the law of without notice. The court knew what the law was because it set it out in its judgment. And Mr. Terry, whose affidavit founded the application, alongside another affidavit, in terms set out why they were proceeding without notice. And can I go to paragraph 117 of his affidavit, which is at tab 14 of the supplemental bundle. The page reference, I should say, is 352, yes. And there, well, if we start at 351, we see a section headed delay. So Mr. Terry is addressing the question of, it could be said that we've delayed, and this is the evidence on that. And then over the page at 115, he has a heading without notice. And in particular, paragraph 117. And the point that is made at 117, which I'll let the court read if you would care to. The point that was being made by Mr. Terry is that here we have a situation where this individual, as we understand it, is now, literally now, competing with us. And it's even worse because we had a debate about this 6 months ago where Dr. Ali signed up to what was being described as the reset, where, look, I'm going to really absolutely accept what my obligations are to my employer, and he signed a letter setting all that out, and here he is again, continuing to act in competition. So the motivation on the part of the claimants was, we need to get this stopped now, ASAP.
Is that a good reason for a without notice application?
Well, the court below, Mr. Justice Constable, took the view that it was, knowing all the facts. But my lord, and that's the critical point I wanted to convey. Nothing was misled. The learned judge was not misled about what the law without notice is, what the facts were. He decided that it was appropriate to apply and proceed without notice. And of course, your lordships will recall that he made a decision that, as regards the disclosure of of bank statements, no, that was not right. I'm not going to hear that without notice. So the judge was alive to proprieties in this regard and decided, I'll hear this and grant this without notice, but this relief I won't grant without notice. But my lord, so we say there was no properly analysed, there was no breach of the duty at all, because the court knew all the facts and it made a decision, and it was persuaded.
What is the position if a judge is aware of all the issues about without notice and decides that, in his view, at the initial stage, it's appropriate to grant an order without notice?
Yes.
And it then comes to the return date, and the return date judge, who is different, takes a different view about that. Is it open to him to say, the first judge got this wrong?
No, it's not.
Or I can decide that this should not have been granted without notice? I mean, you can certainly decide whether to continue it.
That is
another
absolutely
matter.
right. My lord, it's not open to the second judge to second guess what the first judge has done, because it puts the claimant in an impossible position.
I mean, if first judge is misled, then that's another matter, of course.
I do accept that. Absolutely right. That is my answer to that. And my lord, so just pausing there, because I have a secondary submission on this. Pausing there, nobody was misled about anything. The court knew what the law was. Nobody suggested that there's a special rule that you always have to go without notice on these particular rules. And let's say that had been said, then of course that would have been a misstatement. Of course that would have been a misstatement. But
Mr. Grant, can you help me on
yes,
current King's Bench practice? When the ex parte injunction was granted, the usual provision with liberty to apply, but the return date was fixed for nearly 5 weeks ahead.
that's right, my lord.
When I used to be practicing regularly in this kind of case, the usual practice was to fix a return date for a week ahead. And that gave the defendant the opportunity to say early that the ex parte injunction should be discharged. But that doesn't seem to be what happens now.
My lord, my understanding of the relevant practice, and it's something I've spent quite a long time doing, whether I can give a proper answer, of course, is a different matter, is this, that the judges below there are two competing considerations. One is to get the matter into parties as soon as possible in order to avoid potential injustice. The other is that in any heavy case, in 9 out of 10 cases, the return date is actually fixed too early. And let's say I'm acting for the defendants, as I commonly often do. I turn up at the return date and say, look, I'm not ready because I need to amass my arguments, I need to consider all the issues, and therefore the first return date often is set too early and is a kind of dummy return date, that's a wrong term, is a kind of a directions return date. And what I suspect Mr. Justice Constable was trying to do here was to avoid that scenario where everyone piles back into court. A lot of money is spent to no particular effect. But my lord, can I just say this? If we go back to tab 4 of the supplemental bundle, which is the order of Mr. Justice Constable, he actually legislated in a, if I may respectfully say, an entirely sensible and sound way. Because if your lordship turns to page 75 and paragraph 2, your lordship will see that although a return date was fixed for the 24th of July, paragraph 3, at 2, the respondents have a right to apply to the court to vary or discharge this order, as set out at paragraph 14 below. We go to paragraph 14, page 78. They have an absolute right to go back early if they want. So it's not as if they're hamstrung by the 24th. It's not as if they're prevented from doing anything for 5 weeks. If there's any urgent matter which requires court intervention, the respondents had the absolute right to apply instantaneously back to the court. Does that answer your lordship's question?
Yes, I was just asking about current practice.
Yes.
I wasn't criticising.
No. I hope I gave you a satisfactory answer, my lord. But I think the current practice is it's divergent. But I should also say this, that there are different practices when it comes to freezing injunctions, because of course the court understands that a freezing order represents a very substantial interference with a respondent's private life, financial life, etc. And therefore, often it's preferable to have that early. But again, in virtually every freezing order case I've ever done, the first return date proves to be a directions hearing, because the arguments that the respondent wants to deploy are arguments they want to develop, because they're generally of a substantive nature, and 5 days is not enough to develop your arguments, especially when you've got to put in an affidavit of means and all the rest of it in that 5-day period. There's a lot of things generally to do in response to a freezing order. So there are, I should say, just to nuance my answer, that the freezing order jurisdiction perhaps has a different tendency. But again, in as I say, in 9 cases out of 10, in my experience, the first return date, even if it is a week after the ex parte date, is a directions hearing alone, or is compromised towards a fresh return date at a later stage. My lord, that's my, I hope, helpful answer.
May I just ask one question? You may be coming to it.
Yes.
But one of the things you showed us in the witness statement was that we're worried that Dr. Ali will cover his tracks, and that's picked up again at paragraph 30 of Mr. Justice Constable's judgment.
Yes.
And there's a large chunk of the skeleton argument saying there's been no prior correspondence with Dr. Ali. We haven't alerted him, if you like, to what we suspect. And I know you said in your skeleton argument you showed the judge letters about whether he was employing or seeking to employ trainers for a business, but you didn't draw attention to the 31st of May suspension letter, which says you have taken cash payments. You failed to respond to sales fees, but you're going to come to that.
I'm absolutely going to come to that. I'm going to come to that head on as my second submission. The first, I'm still on the first criticism made by the learned judge below, and I've made my submissions about what the judge knew or didn't know, and what was told to him and was not told to him. It's right to say that my learned friends have a specific point, which is that there's a passage in Brearley Block, which was referred to by Mr. Siddle, which and I should show your lordships the actual passage so that I'm not accused of skirting around it. This is, of course, a well-known textbook, and it's at tab 35 of the Bundle of Authorities, where page 934. Does your lordships have that? It's page 934. It's part of a very well-known and well-regarded textbook, of course. And what the editors say at 1434, and you can see it as a red line or highlighted, is occasionally the applicant will decide to seek some of the proposed relief without notice and the balance on notice. And if your lordships can read on. And what I think my learned friend relies upon is the last, particularly the last line of that page, where the editors postulate a scenario where the applicant applies without notice for relief A and B, and then applies with notice for relief C and D, relief D being interim enforcement of restrictive covenants. My lord, Brilliant Block, for all its high reputation, is not legislation, and the editors are not saying at 1434, this is what you have to do. They are, as I see it, merely setting out a way that one might go. It's not being said there, you have to apply for interim enforcement of restrictive covenants on notice, and it is merely a suggestion of what might happen in one particular set of scenarios, or some scenario. So that's what I say about that. But my lord,
did you say that this paragraph or part of it was shown to the judge?
I think some part of the book was shown to the judge.
No,
What my learned friend's
that's
complaint is
wrong.
that
That's not correct, my lord. This point arose at the inter partes hearing. No part of the book was shown to the judge ex parte. All that the judge had before him was the skeleton, which is at the supplemental bundle, tab 2, page 33, paragraph 16, where part of that paragraph is quoted.
Sorry, page 33.
Yes.
that's right. Paragraph 16, the same paragraph is quoted. Now, let's assume I'm wrong on my primary submission, and that it was an error to apply for the injunction as regards the restrictive covenant, the covenant, without notice. Where does this point go? One asks. Now, our respectful submission to this court is that this is a complaint of form, not substance. The reason for that is as follows. The defendants never said below that they had or would have had an answer to an application in June for relief under the covenant. They never said that. Their sole grounds, as your lordship will remember, for seeking to set aside the injunctions, the sole ground was full and frank disclosure. Not that as a matter of substance it should not have been granted, because we have suite of arguments A, B and C, which we'd have deployed had we been asked along to the Constable J hearing. So what the argument, even if I'm wrong on my first point, boils down to on this, is something of a bootstraps argument. We accept, had you got on notice, you would have got the order and we'd have had no defence to the order, or no answer to the order. But because you went without notice, you are therefore destroying your own right through applying to presumptively. And we might test that argument yet further. Well, before I go there, there's one tweak to this, which is that my learned friends say, aha, we did have an argument. We would have had an argument, which is that damages, we'd have said that damages were an adequate remedy. And of course, your lordships will know under the American sign limit rule that that is a question that the court has to ask itself. Now, one tests the seriousness of that argument by saying, well, what did my learned friend argue below before Mr. Justice Bourne? Well, I've scoured his skeleton argument, I've scoured his oral submissions. It was never suggested that damages would be an adequate remedy. And of course, that's because the law is absolutely plain on the question. In restrictive covenant cases like this, damages are never an adequate remedy for all sorts of very sound reasons. My learned friend did even suggest the opposite. And one of the complaints that I'll come on to make about the judge's order.
I did.
No, well, that's not. Well, we have to differ on that because I've looked at the transcript at great length, and there is not one suggestion that this application was being resisted because damages would be an adequate remedy. Now, that argument, as we'll come on to, was basically an argument that the judge himself came up with in his room when after he'd reserved judgment at 4 p.m. on the 17th of October. But my lord, the point goes even further than that, we would say, because it's important to take into account the following factors. One, the employment covenant injunction was doing no more than seeking to uphold a voluntarily entered into contractual promise. All it was doing is, we seek an order from the court requiring you to comply with clause 13 of the contract, and there's no doubt about what clause 13 of the SPA says. That's the first point. The second point is there's never been any suggestion that the order, whether granted ex parte or had it been granted inter partes, would cause Dr. Ali any prejudice or hardship at all. And that, in turn, that point breaks down into three further subpoints. Subpoint one, how can it be a hardship to be injuncted from doing that which you have expressly promised not to do? Subpoint two, as we'll come on to look at in greater detail, Dr. Ali himself had, via his counsel on the 17th, Mr. Solomon, on the 17th of October, said, I don't wish to compete with Derma Med. And we'll see that that fed into some reasoning at a later stage in the judge's judgment. So Dr. Ali himself was saying, even at the same time that he was saying he wasn't bound by the covenants by that stage because he'd accepted the repudiatory breach, I don't wish to compete in any event. That's the second subpoint. And as regards the third subpoint relating to hardship, if there was any hardship at all, which was a hardship for which complaint was being made, Dr. Ali had the right to come straight back to court, as I've shown my lords, under the constable order. And in any event, he could have argued this point on the 24th, but instead he was content to roll it over till October to allow for a mediation. Now, I'm not criticising Dr. Ali for doing that in any shape or form, for effectively saying, look, let's keep the injunction in place until October when we'll have our return. But it does show that this was not an injunction, whether or not granted ex parte, that was causing Dr. Ali any hardship at all. And the third bigger point on the merits, which surely, we say, affect the significance of this breach, if a breach it was, is that the actual evidence that was produced by the order, as I've shown your lordships, showed that Dr. Ali had indeed committed breaches of the non-compete and confidentiality covenants, and he admitted it. So effectively the argument being put forward by my learned friend is, you had as I would characterise it, I mean, I know he disagrees with this and he can make a submission, okay. You had a absolute entitlement to that injunction because there are no answers to it for all the reasons I've explained.
Sorry, which injunction?
The non-compete injunction, in the sense of, had you given notice, there would have been no answer to it. There could be no answer to the injunction being granted. But because you made that one false move in applying ex parte, not only does that involve the injunction being discharged, but it involves you never again being entitled to rely on that covenant. Now, that may be thought to be a pretty bootstraps argument, with the greatest respect.
Well, that puts it a little bit high, doesn't it? Because you are entitled to rely on the covenant to claim damages, but then you've got the difficulties of proving them.
Yes, your lordship is, if I may say so, with respect, completely right. But one might think that's a pretty harsh world to throw my client into. Admitted breach, admitted deliberate and dishonest breach, but you're going to have to prove your damages. And we all know that there's been many judgments of this court and of the High Court over many years that says the reason why damages are, I'm not saying never, because it's dangerous to say never, but almost never an adequate remedy for a and I speak, of course, to judges on this bench who know much more about the law than I do, so I speak with some hesitancy, but my respectful submission is the reason why the courts have said that is because it is so difficult to prove loss when it comes to non-competition injunction. Of course, the other point that judges make.
I know there are cases that do say that, but which in your submission is the clearest statement of that principle?
My lord, we have cited it in our skeleton argument, which I will let me show.
I don't particularly want to look at it, but I just want you to tell me which case you think is the clearest statement.
Yes, I'm going to. I've got a note of it in my submissions. Well, we say the two clearest statements, although they're High Court cases, but they draw on Court of Appeal decisions. So I'm not that they have the weight behind them of the Court of Appeal. Our P14 medical authorities, tab 28, page 725, paragraphs 118 to 119, and city site authorities 34, page 905 is the first page, paragraphs 45 to 46.
Okay.
And the other point that those authorities make, my lords, is that not only is it damages are fearfully generally, because competitive activity is necessarily not done in plain sight, and it's difficult to work out whether one particular client would have not have come to you or not, etc., etc. And of course, it just gives rise to horrendous questions of proof and very long trials. But the other point that is made by the judges, and which is picked up in the two citations I gave to the court, is that the claimant says, well, I didn't bargain for damages. I bargained for a promise that you wouldn't do something. And I want to just uphold that bargain. That's all I really want to do. And I'm asking the court to uphold that bargain for me. But on the judgment below, we're forever debarred from that. Because we went ex parte in respect of a hearing which, having gone into parties, there'd have been no answer to. That's the first breach. And my answer to the first breach, or rather my analysis of where the judge went wrong on the first breach. The second breach, which is the point that my Lord Justice Lewis mentioned a few minutes ago. That's the second breach is the failure to show the court the suspension letter.
Well, before you get on to the details of it, although you put it into a separate box, I've been looking at paragraph 64 of the skeleton at supplementary tab 2.
Yes.
And that says there was no correspondence and that the claimant hadn't been told about the allegations. And that's picked up in the judgment of Mr. Justice Constable. And it's all to do with the fact they didn't want to tell Dr. Ali that they had suspicions because he might cover his tracks. And the point is, you need to tell him enough. Oh, sorry, I put it in way. The point put against you is that if in fact you had told him that there wasn't this risk of him being unawares and not covering his tracks, that you should have told the judge that in fact he had already been alerted to the allegation and there was no need to have an ex parte injunction to prevent him, as you put it, covering his tracks. So it can't be entirely divorced from the first point.
Well, my lord, what your lordship is looking at is page 54, I think, of tab of the supplementary bundle,
54.
where yes, but if the court, Mr. Siddle precisely said there has been correspondence, and he referred to it in terms at little b, and I'm going to show your lordships what he showed the court. He did not say that there's been no correspondence between the parties in the last so many weeks or so many months. That's not what he said. He says there has been correspondence, but the point he was, I think, is this your, I think, little a. The point he was seeking to suggest, and quite rightly in my respectful submission, is that there had not been correspondence which would tip off Dr. Ali in such a way as to make him, well, covering your tracks in this context can only mean deleting documents on your computer. and thereby rendering the imaging order nugatory in some way. Now, I'm going to directly meet that point head on, my lord, because I'm going to show the court, well, let me preface the submission in this way. This point is dealt with at paragraph 20 of Mr. Justice Bourne's judgment.
Well, it starts with Mr. Justice Constable as well, because it's what he misled. If you look at page 96 at the top, it's part of paragraph 30, he says, I accept that raising the issues directly by way of pre-action correspondence could give the ability for Dr. Ali further to cover his tracks, and that act gives the reasons for applying ex parte.
Can your lordship remind me which paragraph that is? I'm so sorry.
It's the inside paragraph 30,
Yeah.
at the top of page 96.
Thank you.
And what I'm just taking, when you take the document, show us the document that you say showed that the judge would have been in no doubt that Dr. Ali had been told of the suspicions of diversion and stealing, as opposed to building up another company.
No.
The judge wouldn't have been under misapprehension.
My lord, what Mr. Justice Constable meant at paragraph 30 he says this, as your lordship rightly points out, I accept that raising the issues directly by way of pre-action correspondence could give the ability for Dr. Ali to cover his tracks, as very clearly seems to have been the case in relation to the deletion of DM messages. So the point that was in issue there was, this is as regards
Paragraph
covering of
64.
tracks, as regards covering. Now, covering of tracks only has any meaning as regards deletion of incriminating material. I.e., and this is sometimes said in respect of freezing order applications, if you say, I'm concerned you're about to spirit away your wealth from, or your assets from the jurisdiction, then that could go against obtaining a freezing order ex parte. Now, nothing was said between the parties before the hearing of the 22nd of June that could possibly have tipped off Dr. Ali that we were seeking, my clients were going to seek an imaging order so as to, or suspected that he might be at risk of deleting documents. That's all that covering your tracks can conceivably mean in that scenario. And the point goes further with respect. No one has suggested that the imaging order should have been set aside. No one has impeached or challenged the imaging order. It was made, it was complied with, belatedly, but complied with, and there is now an image held by Kroll, which will be utilised for the purposes of the litigation going forward. So the covering of the tracks difficulty relates and can relate only to the question of whether or not an imaging order was properly granted ex parte. But no one's challenged that. The challenge that has been made, and which was accepted by Mr. Justice Bourne, was whether or not a particular document should have been shown to the court. Now, and I wish to just first of all show your lordships what Mr. Justice Bourne said on that. It's paragraph 20 of his judgment, tab 6 of the core bundle, page 59, where the contention is, or not the contention, the judgment I should say, is I also consider the judge should have been shown the letter dated the 31st, telling Dr. Ali that the claimants wished to investigate allegations that he'd taken cash payments, not properly responded to cash leads, etc. That too would have led the judge to ask why it was thought necessary to restrain competition without notice. Now, let me now go, if I may, to that letter, just to see what the letter said. That is tab 42 of the supplemental bundle. It's the letter dated the 31st of May, and it's a letter of suspension. Now, I think the sole relevant or potentially relevant passage of that letter is the first half of it, where the rest of it is of a procedural nature, I think I can fairly say. So it's the 4 bullet points of the 31st of May letter. You've taken cash payments, You failed to respond properly to sales leads, clinical records, disloyal in suggesting to senior employees that they should leave the company. Now, as regards the fourth bullet point, I'm not sure that had any relevance of any sort at all to anyone for the purposes of the ex parte order. Sorry?
Can you finish reading the whole bullet point, please?
I'm going to ask the court. I've asked the court to read the 4 bullet points. So the fourth bullet point was not relevant to the relief being sought. The third bullet point was not relevant to the relief being sought. Arguably relevant was bullet points 1 and 2, and possibly only bullet point 1. Now, that gives rise to the question, because this letter was undoubtedly not shown to the ex parte judge. That gives rise to the question, well, what was the court told at first instance, and why was it relevant? Now, can I ask you now, my lords, to show? I'm going to show you, lords, what the court was shown. If your lordships go to tab 45, please. This is a letter from Loch Lord, my solicitors, on the 13th of June. And Mr. Siddle expressly asked the court to read paras 13, 16 and 17. And I'm not going to read them out to your lordships, if your lordships would bear with me. But 13, 16 and 17. So these are complaints and suspicions. These are suspicions being articulated by my solicitors on behalf of my clients to Dr. Ali a week before the hearing, which Constable J is asked in terms to read. Para 13, then para 16, over at page 674. And in terms, my lords, your lordship will see 16.4. So the court knew, Constable J knew, that we had written to Dr. Ali before the hearing, requiring him to cease and desist engaging in competitive activity. And then para 17. All that was read out. Secondly, my lords, none of this is mentioned by the learned judge below, I should say. Secondly, my lord, Mr. Siddle then said, can you please look at DWF's responsive letter, which is at tab 46, and in particular paragraphs 5, 6 and 8. And again, I'm going to ask the court, page 677, just to cast an eye over those 3 paragraphs. Para 6, they know we are suggesting he's in the process of setting up a competing business, and they deny it. Wrongly deny it, no fault of DWF, of course. And then, my lords, the paranoia quotation comes from paragraph 8.
The impression I'm forming, it may be from the affidavit as well, is that they're skirting around the issue and they're saying you're getting ready to set up a competing business. You're getting trainers and people, employees who'll be ready to administer the Botox if administers the right dose. But what they don't say is, we also told him we will investigate him taking money from clients that should have been ours.
Well, my lord, let me go to the affidavit evidence. Let's go to Mr. Terry's affidavit, please. And particularly, let's go to, and that's tab 13, so sorry.
Just,
Tab 13 yeah, of the supplemental.
Mr. Grant, just
I've got that wrong.
noting that the silent clock has metaphorically struck 12. How are we doing on time.
Well,
You need to finish by 1 o'clock.
yeah, well, I'm going to endeavour to do so, my lord.
Good, right.
So, it's tab 14, I'm so sorry, of the supplemental bundle. That's Mr. Terry's affidavit.
Yes.
We go to paragraph 17. It is said in terms that he was suspended on the 31st of May. That's para 17. Independent investigation concerning his conduct. It said that Dr. Ali then resigned in response. That's what paragraph 17 says. Then if we go to paragraph 54, and this is what Mr. Terry says. A decision was therefore taken that we had to act on the messages explained in paragraph 38. I'm going to go back to those. And the cash payment rumours and the potential poaching of Dr. Thiara and Mr. Pywell. And these matters all called for an explanation. It was agreed that Mr. Ali would be suspended from work. So that was read by the court. Mr. Justice Constable expressly said, I have read Mr. Terry's affidavit. And that's what Mr. Terry said at para 54. But let's just go back to what is said at para 38 of the cash payment rules. Para 38 is page 335, where in terms the court is told that Miss Stratton has noted deletion of documents, creating suspicion about the activity, DMs, creating suspicion about the activities undertaken by Dr. Ali. And then para 52, back at 338, that's the cash payments rumours. Around this time, there were unsubstantiated rumours that Dr. Ali had been taking cash payments. So, what we suggest with respect to the court is that the judge at first instance at the ex parte hearing, although he did not, it's right to say, have the letter itself, everything that was stated in that letter of relevance or potential relevance was stated in the correspondence I've shown the court and in the affidavit. And then if you go to finally paragraph 57 of the same affidavit, 339, the court was told in terms that he'd accepted payments in cash. And of course, that's precisely the point that is said at bullet point 1 of the letter of suspension. So the submission that I respectfully make to this court is that on analysis, nothing in the suspension letter says anything more than what the court knew already via Mr. Terry's affidavit or via the correspondence that was expressly shown to the court and which the court was expressly asked to read. But, my lords, the matter goes further than that. And it's this, which is, what's the relevance to tipping off of the court seeing that letter? No, that letter does not say, or in any way suggest to any right-thinking person, you better start deleting all your documents because we're going to get an imaging order. It doesn't infer that. And in any event, it's an odd argument, my lords, which this appears to be the ultimate gravamen of the argument. You had tipped off Dr. Ali that you were about to obtain some form of image or evidence preservation order, and therefore you should have told the court that because he might have already done it.
No, you should have told the court that because the court might have said, well, do we need to proceed without notice?
Well, my lord,
That's why you should have told the court.
Well, with respect, I respectfully say no for this reason. The tipping off point can only be relevant to the preservation of evidence and the imaging order. And no one suggests that application should have been made inter partes. All this goes to is the tipping off question can only be relevant to the imaging order. And that necessarily had to be made ex parte, notwithstanding anything, and no one suggests otherwise. So it's an odd question as to where it goes. And if my lord is right, and if I'm wrong and my lord is right, that it goes to the question of whether to obtain relief for the non-compete injunction inter partes, then it is bound up with my first submission, and all the submissions I made about the ultimate futility and aridness of the point are applicable. My lords, I now move on, conscious of the time, to the third ground of injunction, the third ground on which Mr. Justice Bourne discharged the order. And that was the width of the confidentiality injunction. And that's the subject of paragraph 21 of the learned judge's judgment. We're back at tab 6 of the core bundle. And it is, the complaint is it was hopelessly wide, because it had the words including but not limited to, which I've shown the court, which was the subject of some negative words by Lord Justice Beatson in Caterpillar. Now, there are a number of highly material facts which it is important to bear in mind and which the court below simply ignored in assessing the gravity of that breach. And I should say that Mr. Siddle accepted before the judge below that he had fallen into error in casting the injunction in the way that it was cast. But in mitigation of that, they were very powerful.
Just to clarify that, I think the error which he accepted was the words including but not limited.
Exactly.
Whereas the judge makes a further point that it required a judgment to be made about what is reasonably regarded as confidential. And I don't think Mr. Siddle did accept that, and I'm not sure that you do, because those words are still in the order that you're asking for.
Well, I'll come to that. But he accepted he'd fallen into. It was a short. The acceptance of falling into error. He did say that, and I'll come to the transcript if I need to. Well, I'll tell you what the transcript says. Or rather, it's page 286 of tab 13 is where he concedes, he quotes, fell into error. Now, the mitigation, my lord, was very powerful and was ignored by the judge below. The first, and I'm going to go through this as quickly as I can. The first point was that the injunction that was granted did no more than parrot the wording of the contract which Miss Dr. Ali had expressly entered into with legal advice. It wasn't just plucked out of thin air. Some random words weren't thrown together. The wording was directly drawn from the wording of the SPA and the obligation entered into not to misuse confidential information. That's the first point. The second point is that when DWF wrote their letter of the 30th of June setting out a whole bunch of full and frank disclosure breaches, nothing was said about this, about the width of the confidentiality injunction as a ground of complaint. So it wasn't identified then, on the 30th. The next thing that happens, as your lordships will recall, is Dr. Ali puts in his witness statement. Now, I do want to show your lordships that witness statement for this purpose. It is at tab 18, page 382 of the supplemental bundle. Now, what Dr. Ali said at paragraph 7.8, page 385, on the 18th of July, is this: I am willing to give confidentiality in undertakings limited to truly confidential information. See, he offered up an undertaking. Currently, however, I do not know what the express extent of the order is. So that was the complaint, or whether it's a complaint or not is another matter. That's what was said at 7.8. Then he went on, and then let's go to paragraph 88, please, of the same document, where he returns to this point. page 472. Sorry, 427. Your Lordships will see at the end, heading the confidentiality injunction. I do not accept the definition of confidentiality is vague, which is vague and not exhausted. I'm willing to give the confidentiality undertakings if limited. And then he says this at paragraph 89. I understand that my solicitors will write to the solicitors acting for the claimants about the wording of those undertakings. So anyone reading that affidavit or witness statement would think, right, there's a complaint about the width of the injunction, and Deed Relief are going to propose some narrow injunctions. They never did, my lord, they never did. But it's not cast as a full and frank disclosure breach, and instead Dr. Ali is saying, I'm willing to give undertakings on a narrower basis, which is entirely inconsistent with the stance taken by Dr. Ali before Mr. Justice Bourne, which was that this in and of itself justifies discharge of the injunction and not regrant of it. How are those two positions consistent?
Are you saying it's not a material non-disclosure, or it is, because relevant authorities weren't drawn to the attention of the court?
I'm saying
it's not so serious as to merit discharging the injunction.
I'm saying two things. One, I'm not in any way trying to resile from Mr. Sybil's acceptance that he had fallen into error. I say it is an immaterial. If it was a non-disclosure, it's an immaterial one. I don't accept it was a non-disclosure, but I accept that Mr. Siddle fell into error. However you want to characterise that, it was an immaterial error. But in any event, it's not an error that justified discharge and non-regrant. Because let me make that point good, if I may. So on the 18th of July, when this witness statement was put in, we know that there's the application notices served by the Dr. Ali, and his mind is very much concentrated on his full and frank disclosure points. That's the sole basis of the discharge application. But it's not raised, at this point it's not raised as a full and frank disclosure point, it's raised as a point for discussion and narrowing. Then we have the consent order, and Dr. Ali is entirely content, it would appear, for the injunction to continue as it was granted for another 3 months. He's not saying, look, it really is causing me problems, this injunction. Can we actually tweak it a bit? He says he's going to write, they're going to write. He never does. What then happened, my lords, is that the consent order was entered into. There's no tweaking of the injunction. DWF don't ask for that. Things trundle on to October. And it was only in my learned friend Mr. Solomon's skeleton argument served on the Friday that he now converts this point from being we need to discuss it, let's do some undertakings, let's work out an accommodation, into we're going to apply to discharge and rely on this to discharge and not regrant as a breach of the obligation of full and frank disclosure. So the point only becomes an FFD point, using that acronym if I may, on the 13th of October. And we suppose that in our skeleton argument, we have supposed that while Mr. Solomon was beavering away in his chambers, working on his skeleton argument, this occurred to him as a point, and that's not been gainsaid.
Where is sorry to interrupt, where is the first crystallisation of the non-disclosures on which the defendants relied? You showed us the application notice. I don't think that identified them.
The affidavit, the witness statement number 2 on the 18th of July has a section on non-disclosures.
That's paragraph 76, is it?
To 85,
Yeah.
not mentioned. Then there's silence. And then the first articulation of this point is the skeleton argument on the 13th of October before the 17th of October hearing. And the response to suddenly this being turned into a full and frank disclosure point at the very last minute, the response on the part of my solicitors, having received nothing from DWF contrary to the promise or contrary to the indication given by Dr. Ali on the 17th of July, 18th of July, was to write that saying, if the wording is too wide, here's some narrower wording. And that's...
Well, I was looking at those paragraphs and I couldn't see the suspension letter mentioned either, is it?
By Dr. Ali.
Yeah, if one is wanting to know what issues are we going to have to prepare for to meet an allegation of non-disclosure, just wondering where you find them.
Well, I may have to leave that to my only friend. it's maybe a fair, well, anything the Lordship says is a fair point, of course, but it may be a very fair point. Quite. Well, I mean, what one feels, well, the impression one does get is that the defendant's sitting down and thinking, the only way we can get rid of this injunction is by scrabbling around, trying to work out as many non-disclosures as possible, given that we actually got no answer to the underlying point.
Anyway, so I think you had 2 points, I think. One was it's an error, but it's immaterial. I don't think we got as far as your second.
Well, the second error is that it's easily it was easily solvable by the wording we put forward in our letter of the 17th of October. And what is so odd, my lord, is that even in Mr. Solomon's skeleton argument of the 13th of October, he says, paragraph 82, I think it is, my client is willing to give undertakings on relation to confidentiality. And you'd have thought, well, this could have led to a debate and a discussion in a mature and sensible way, leading to some undertakings or injunctions. But in fact, nothing further is said about that by my learned friend. And the judge, what we're left with is the judge discharges the injunction, refuses to re-grant it, and my clients have got the benefit of a contractual right to non-misuse of confidential information, and emerge from the hearing of the 17th of October. I mean, to call it pretty deflated might be an understatement, thinking, well, we've now got nothing. Even though Dr. Ali has said all along, I am willing to give undertakings, he's never offered the undertakings or crafted them. We have then responsibly offered some narrower injunctions, whether by way of injunction or undertaking. The judge has just ignored them. The judgment simply says nothing at all about the narrowing of the undertaking. It doesn't say it was too wide still. He just takes the view that we are to be condemned and condemned forever for Mr. Siddle's candidly admitted error, though in the pantheon of errors, he might be described as a pretty minor one, if I may respectfully suggest. And the further point is that at no stage has Dr. Ali said, I've actually suffered prejudice from the width of the injunction, as originally granted. Quite the opposite. He was quite content to let it roll for 4 months. So what we suggest, my lords, is we're quite content for any injunction that your lordships would be content to. I'm running ahead of myself. To be in the narrower form, which we have, I hope, conscientiously and responsibly responded to Mr. Solomon's point in his skeleton argument as quickly as possible. It was only made on the Friday. By the Tuesday, we've set out new wording, but that's just ignored. And my lord, there is a precise precedent for this scenario in the case which we cite in our skeleton called UK Power Reserve, where an injunction is granted ex parte in 2 wide terms. It goes back to the inter partes hearing, and the judge says, well, we can narrow the injunction and move it forward, no problem. And that's paragraphs 52 to 54 and 101 of the UK Power Reserve case, Authority Bundle 20. I don't have time to show the court that authority, but it's referred to in our skeleton argument.
So, do you have time to give the reference again a bit more
I
slowly?
do. No, I do apologise. No, I do. I've always got time, my lord. Authorities Bundle tab 20, paragraphs 52 to 54 and 101.
Thank you.
An almost exact scenario, an exact analogy to what happened here. But instead, for reasons which the court below chooses not to explain at all, we are condemned and damned for a breach which didn't even occur to my learned friend Mr. Solomon
right, Mr.
until
Wright.
the 13th.
You've made that.
My lord, I move on.
Are you going on to
Fourth. And now to the fourth
yes.
breach, which is
Right.
the failure to inform the court that my client was in breach of contract, well, unarguably in breach of contract. My lord, this is the fourth head of Mr. Justice Bourne's judgment. It is paragraph 22 of his judgment, tab 6, and it is the statement that, well, the statement appears to be that Mr. Siddle was at fault and my clients were at fault, therefore, because Mr. Siddle did not say, by the way, my lord, we owe Dr. Ali £630,000 odd, and we have no defence to that We have there is no defence to that liability, and that's just wrong on many levels.
Well, was the judge told at all that this sum was being retained by?
The judge was told. The judge was told that that Dr. Ali had claims under the SPA, and they were contentious claims.
Yes.
Can I show the court what the judge was told?
Yes, please.
So, taking it as briefly as I can, we have Mr. Terry's first affidavit, which is tab 14.
Yes.
Para 106, page 350. That's the first point. Dispute over the earn-out payments under the SPA. Loch Lord wrote on the 13th, and there was a letter of claim sent by DWF on the 26th. Says Mr. Terry of 106.
Is this mentioned in the skeleton argument? Mr. Siddle's skeleton argument?
Well, Mr. Siddle, Mr. Justice Constable said in terms that he'd read Mr. Terry's affidavit, and Mr. Siddle actually showed whether that paragraph was expressly referred to in Mr. Siddle's skeleton argument. I'm going to let my learned junior help me on that. But while he does so, can I? Thank you. My learned juniors has pointed me to page 54, tab 2, supplemental bundle. We've already looked at it in a slightly different context, where Mr. Siddle says 6 lines down, we're referring to correspondence between the parties. The correspondence was generated by D1's asserted claims against C.
Sorry, which paragraph?
It's page 54. It's little b. It's paragraph 64b, but it's page 54.
It seems to me that there are 4 elements in what Mr. Justice Bourne said ought to have been said to Mr. Justice Constable.
Yes.
The first is that you failed to pay an amount which, at the time, you accepted had accrued. The second is that there was a no set-off clause in the contract. The third is that there was at least an argument that because of that clause you had no defence. I know that now you've thought of reasons why you might have. And the fourth was that you had advanced no other reason than set-off for not paying the money. And as I understand it, although you say that there were disputes about the earn-off payments about which the judge was told, he wasn't told very much about them, and he wasn't told specifically any of those 4 things. If I'm wrong about that, I'd like to know where he was told those.
Okay, my lord, thank you. Can I just, when I do my suite of things that the judge was shown, I've shown your lordship Mr. Terry's affidavit. I've shown your lordship Mr. Siddle's skeleton.
On the affidavit, can you give us the corresponding page numbers? It says 489 to 99 of the trial bundle, because they didn't seem to marry up with 499.
No, these are the bundles for the yes. So you're quite right, my lord. So the page 489 is a reference to the letter of claim, which is in the supplemental bundle at tab 41. So that's page 652. That's the letter of claim. And the letter from Loch Lord of the 23rd of June is at tab 40.
Hold on, we're looking to 2 things. One, I'm just trying to marry up as a purely
Yes.
technical matter. Page references in an affidavit, which have been superseded because the bundles have been repaginated.
quite right.
And therefore difficult for me to read the witness statement and understand what he's referring to.
No, I quite
And I understand that page 489 to 499 is page 652 in our bundle.
Quite right.
Right.
And page 470 is the letter of the 13th of June, which is Loch Lord's letter, dated is at 669.
That's not referred to in the witness statement, is it?
It is.
where
Third line down, Locklord wrote to DWF on the 13th of June 2023 to advise them a response will be sent by the 23rd of June.
sorry, are you on page 54? I'm really sorry about this.
No, I'm looking at the affidavit, Mr. Terry's affidavit.
Right. Okay.
Sorry.
And that's 14, isn't it?
Yes, that's 14, page 350. I'm so sorry, my lord. But you're quite right. The letter that's referred to by Mr. Siddle in his skeleton at 489, that's the letter of claim, which is referred to by Mr. Terry at 106. Can I? I'm just conscious of the time, so I'm going to have to. The next thing that was shown to the judge was paragraph 38 of DWF's letter of claim. That is tab 41, page 660. This was read out. This was not read out by, but Mr. Siddle asked Mr. Justice Counsel to read paragraph 38, page 660. Where DWF saying your clients are guilty of a vendetta, and they're guilty of a vendetta to try to use whatever means they can to avoid paying sums due to our clients pursuant to SPA. So that Mr. Justice Constable knew that. He also was shown paragraph 4 of DWF's letter of the 8th of June. That is tab 44 of the same bundle, my lords. And paragraph 4 is page 666. Now, to return to my lord's questions. The court was told that Dr. Ali was asserting that sums were due to him under the SPA, and that my clients were refusing to pay pursuant to a vendetta. He was not told that the sum was £630,000. That figure was not told him. He was not told that by a letter of the 13th of April, Loch Lord had said certain things. Now, my learned friends cleaved to that letter and relied on it heavily below, and it's important that we look at it. It's tab 39, page 648. It's a short letter written by Loch Lord to DWF before we knew what we then discovered, which prompted the application. What Loch Lord say in the third paragraph, there is no dispute that the conditions in respect to the earn-out have been met. Does your lordship see that letter? 648, tab 39.
Yeah.
Now, that was not shown to the judge at first instance, Constable J. I say there was absolutely no need or reason to show that letter to Constable J. That was not an acceptance, irrevocable acceptance, that sums had become due and owing. It was an acceptance that the conditions within the mechanism of the earn-out clause, which is clause 6.1 and following, had been met. That letter was written before we discovered, on our side of the court, of the multiple breaches that Dr. Ali was, so we say, and so we say he admits, guilty of. By the time we got to the hearing in June, our view, which remains our view, is that those sums are not payable and are not due. And they are not due for the reasons articulated by Mr. Siddle in his skeleton argument before Mr. Justice Bourne at paragraph 48. But further, my lord, they are not due because on any sensible reading of the no set-off clause, it does not extend to claims that are outside of the claims defined at clause 11.1. Clause 11.1 of the SPA says, this clause applies, well, let's look at it, I don't want to paraphrase it. SPA, tab 21 of the supplemental bundle, page 486. I have to take this quickly.
Yes, you are getting quite quickly. Sorry to be slow.
No.
Just
I'm very,
show me which,
So,
which
set-off clauses are-
paragraphs of Mr. Siddle's skeleton argument refer to this non-payment. You said that the sum of 600,000 isn't mentioned, but where is the
well,
issue mentioned at all?
Mr. Siddle refers to the non-payment, to the fact there has been correspondence whereby claimant is being intimated by DWF, the paragraph 64B. That's page 54 of the bundle. What I'm now at, if that's, is just very briefly to show your lordship that my learned friend's assertion or contention that the set-off or no set-off clause effectively makes this absolutely payable is just wrong, because the set-off clause is in terms applicable to certain types of claim identified at clause 11.1. And what the contract says is if the purchaser makes various claims defined as a claim, the following provisions of this clause shall apply. Now, the particular claim, which was eventually served, and the contentions before the court, well then we've got a whole bunch of other claims which are not caught by the SPA. And of course, and we've got claims in fraud, we've got claims for remuneration, forfeiture of remuneration under the so-called image view principle. We've got claims at paragraphs 87 to 89 of the POCs that, given that Dr. Ali was hiding from us the fact that he was engaging in a dishonest campaign of competition, we would have sacked him had we known. He was under an obligation to tell us. We'd have sacked him much earlier. He had never become due to the earn-out clauses. So we've got a whole array of arguments as to why this sum is not due. The letter from Loch Lord of the 13th of April did not say it is due. It says that the conditions have been met and they are internal conditions. And in any event, by 2 months later, once we discovered all the facts about Dr. Ali's dishonesty, that cast an entirely different light. So my submission to this court is this, in essence. Here we had a contract which was extant and alive. Here we had the clearest evidence that Dr. Ali was breaching that contract in serious and dishonest ways. There was a contention on the part of Dr. Ali that he was owed a sum of money under the contract. The fact that there was such a contention was disclosed to the judge. The fact that it was not unarguably due was not disclosed to the judge because it was not unarguably due. It was heavily contentiously non-due. Whether it's due or not, of course, is a matter for a trial.
Can I just ask you to pause for a moment, Mr. Grant?
Please.
I wonder if you've been underclaimed your case, which is rare. If we had the skeleton in front of us, because I've been trying to work out what the judge was told, and you know I've been obsessed with page 54 of the bundle and paragraph 64B, and
Yes.
about 8 lines down, there's a reference in bold to 489 to 99, and you said that's pages 652 to 669 of our bundle. So that's what the judge was told in the skeleton argument, and he could have gone and looked at our 652 to 489. And if you look at that, and if you look at 657, it does actually say the figure is £633,000. And if you look over the page at paragraph 27, it does deal with clause 11 and the set-off clause not applying and so on. So I wonder whether you're being unduly modest in your claims.
My lord is very kind. My lord is very kind, and I will happily embrace that.
If it's right, not if it's wrong.
Well, no, what I have to accept is that Mr. Siddle did not say, having cited it in terms in his skeleton to the judge, and I want to bury your face in that letter, Judge. He did not say that, but he went pretty far, and one steps back and asks this question. Let's assume against me that somehow Mr. Siddle erred, and I can't for the life of me see how he did. given that this was a claim for enforcement of injunctions, how is it significant or material to the decision Mr. Justice Constable to make? No one has ever suggested that the fact that there was a contentious sum of money owing in the other direction could conceivably be relevant to the upholding of these injunctions. All that is said by my learned friend is that, we subsequently accepted the repudiatory breach. Well, that acceptance is highly contentious. My learned friend says you can decide now that the repudiation was correct. That's not a realistic submission. And therefore, where does it go? It's one of those questions where it doesn't go anywhere, these points. My learned friend has to make good this point, has to rely on submissions in his skeleton argument. I'm looking at paragraph 57, where he says, quote, C's plainly have no arguable defence. Well, that's just not right. He then has to say, to make good this contention, that we were obliged to mention that our clients were in ongoing repudiatory breach of the contract. That's the submission that is made before your lordships, that we were obliged, Mr. Siddle was obliged under the full and frank disclosure rule to say, we're an ongoing repudiatory breach, my lord, to Mr. Justice Constable. Well, we don't accept we are. We don't accept in any shape or form we are. So why should Mr. Siddle have been obliged to say that?
Well,
So
what you're required to do is to anticipate what the other side's argument will be, obviously within the bounds of reason,
yes.
and to identify those to the judge, together with any response that you may have to explain why those arguments are not good.
Well, there was no suggestion at all by Mr. Dr. Ali or his solicitors that these were repudiatory breaches. That the failure to pay the 633 was repudiatory.
Well, just pause again. I thought you had shown the judge page 666, and it's probably my fault, but the bottom paragraph 5, the letter that I thought you'd said was shown to the judge, actually says that Dr. Ali says he's resigned with immediate effect from his employment because Derma Med are in repudiatory breach.
No, repudiatory breach of the employment contract.
Right, not
the SP. That's the
not
vital
the share
difference.
agreement, just the employment contract.
Yeah, that's the vital difference.
Right.
So I mean, I just don't accept that it was incumbent on Mr. Siddle to think. There's been a lot of debate about this. There's been lots of toing and froing back and forth about this £630,000 odd. Nobody's ever suggested that we're going to repudiate, or we might repudiate, or accept a repudiatory breach and respect it. We want the money. Is what Dr. Ali's tenor has been. I want to enforce the contract, not bring it to an end. So the idea that Mr. Siddle had to think, well, perhaps they might actually decide to treat this as repudiatory. I mean, how it defeats my understanding how it could be described as repudiatory at all. And the judge below did not accept that it could be properly described as repudiatory at that stage, a matter for trial. But it just wasn't the duty of Mr. Siddle to scurry around and start divining possible responses when everything that had been said so far was, we want the money. We want to uphold the SPA rather than bring it to an end. My lord, I think I'm going to have to move on now because I'm conscious of the time. My lord, there is a contention made by my learned friends about a cross undertaking. And that was not one which was relied upon to discharge the injunction, but they now seem to rely on it. Can I leave that and see what my learned friend says about that? And because it's a new point that he makes, and I don't want to let me keep my countenance on that, hold my cards to my chest, or I don't say that in that sense because I'm absolutely clear about the answer. But I won't say anything more about that. Well, that leads me to ground 2 of my appeal, and your lordships will know that ground 2 of my grounds of appeal are to the effect that the judge misapprehended the gravity of the breaches and failed critically to take into account the wider circumstances. And your lordship knows what I say the wider circumstances are. And in fact, it's important for us to look briefly at what the judge did say on this, the learned judge did say. In fact, tab 6, bundle 4 bundle, paragraph 24, where it's said in very short order, page 60, the judge says, given the overall serious failure, which I respectfully contest, I have no doubt the order should be discharged. And there it is. Now, the only thing he said about the law of full and frank disclosure is at paragraph 17, page 58, which is with respect, not a full and accurate summary of the law. And what we respectfully say under ground 2 is that what is said in Tugashev, which is the most recent iteration of the law, is, and I'm going to take your lordship back to the authorities bundle for a second. Tab 27, page 697, and in particular, the law is stated by Mrs. Justice Carr, as she then was at 699. I'm going to ignore most of it because it's well known to your lordships, of course, and just concentrate on Roman 12. Page 700, over to 701. Now, I hardly need say this to this court, especially knowing that Lord Justice Males in Europe laid down a number of dicta which were very much embraced, if I may say so, by the judge in Tugachev, and in particular words that actually derive from Europe. Penultimate line, the overriding consideration will always be the interests of justice. And then there are considerations over the page. I don't have time to take the court through seriatim. The judge at first instance did not, in any shape or form, and quite plainly did not, on the face of his judgment, having considered the alleged failures, step back and say, well, given that Dr. Ali's admitted a dishonest course of conduct, and given that all the concerns that prompted this application ex parte have been justified, and given there are no actual defences to this application, or that subject to a couple of points I'm going to come on to, would it be right to discharge this injunction? What are the interests of justice? By reference to the 4 factors identified by the judge in Tugashev at Roman 12. He never did that. And that was an error in my respectful submission. And we say that had he done so, had he been guided by the learning of Tugashev and all the cases that came before, which are given proper reference by Mrs. Justice Carr, she then was at the end of that paragraph, including Eurov. Had the judge done that, we say there was only one answer he could have come to, which is that the injunction should not be discharged. And let me very briefly give you the 5 reasons that I respectfully say would have led to that. Reason 1 is that the breaches were, if they were breaches at all, they were not at the serious end of the spectrum, and I've made submissions about that already. Reason 2, this Dr. Ali had by this stage demonstrated and admitted very serious wrongdoing. And the application and the reasons for the application were entirely justified. And therefore, we say the overall justice of the case overwhelmingly tended against discharge. But the matter went further than that. The injunctions that were set aside were injunctions that did no more and no less than uphold freely entered into contractual promises. And a sub-reason there is that as regards the confidentiality aspect, there was a promise of an undertaking which then evaporated before Mr. Justice Bourne when it became clear where the wind was blowing. So, and I've already made submissions on the peculiarity of that scenario. I'm willing to give undertakings. oh, by the way, can you discharge the entire injunction in all the suite of relief because your confidentiality injunction's too wide? The total contradiction. And another further reason in that larger head is that Dr. Ali says, apparently, through the mouth of my learned friend, I'm not proposing to compete in any event. So I'm willing to somehow agree not to do that which I'm debarred from doing by the contract, which the injunction is designed to prevent. Those are a set of reasons under reason 3. Reason 4, I respectfully suggest that this was not an example of a cavalier application, and I've made submissions on that. And reason 5 is, we would say, it's clear. I know this is not definitive, I accept that, but it's obvious that had the matter gone inter partes, the relief would have been granted in any event. And that surely, and not surely, definitively, and certainly goes to the gravity of the breach and the response of the court to the breach. And I've made submissions on that as well. Now, so for all those reasons, we say that under ground 2, it was a wrong exercise of an evaluative judgment to discharge the injunctions. My lord, that leads me to ground 3. And ground 3 is the ground relating to the injunction going forward. And your lordships can please have up Mr. Justice Bourne's judgment, because he goes on to this in paragraph 25. And what he says, my lords, as regards the application for continuation, not that the breaches that I've identified debar the claimant from seeking that relief. He looks at this through an entirely new lens, paragraph 25 onwards. He says, looking forward in respect to the continuation application, should I grant relief? The answer is none is necessary, therefore I'm not going to grant it. And the 2 reasons he gives that none is necessary are, one, that Dr. Ali had gone on record as saying that he will not do those things. Now, what does that mean? What does gone on record as not doing those things mean? Well, it refers to, I'm afraid I have to go back to this because your lordships might be a bit bemused by that. I'm going to have to go back to the supplemental bundle and to go back to what my learned friend Mr. Solomon said. This is supplemental bundle tab 13. This is the transcript. Tab 13, page 313. Where the learned judge below is debating matters with Mr. Solomon, and he wants to know where we're going forward on this case. And Mr. Justice Bourne at little g at 313 says, at the moment he's subject to Constable J's order. If I discharge it, he ceases to be so subject, yes. But he knows he's facing a claim. Over the page, yes. Is your position, then your lordships can read what Mr. Justice Bourne poses to Mr. Solomon. It doesn't need to be ordered to compete. Is that your position? Yes, that is my submission. As a matter of practicality, you've seen what he's promised in his witness statement. My learned friend has read it to you. In respect, he'd be willing not to compete. Well,
read the next sentence.
But the starting point is there's been non-disclosure. It ought to be discharged. So that's what Mr. Solomon says. And we think, and your lordship may think, well, what did he say in this witness statement that has allowed my learned friend to say that he's promised that he won't compete in any event? And that is a reference, I believe, to the witness statement of the first defendant at paragraph 84. It's supplemental bundle 8, tab 18. And it's page 427. And I know this is the case because this is the paragraph that was quoted by Mr. Sidnall, which Mr. Solomon is cross-referring to. So if your lordship then goes straight to tab 18, page 427, paragraph 84, all in fact we see that Mr. Ali is saying, I would have agreed not to perform any treatments at least until the date of any hearing.
So I just don't see where I'm at page 427.
Paragraph 84, that's the sentence or the paragraph that Mr. Solomon relied upon in making the submission that Dr. Ali was not proposing to compete in any event, which in turn informed Mr. Justice Bourne's decision that there was no further necessity for injunctive relief. And the short submission I'm making on this point alone is that paragraph 84 in no shape or form bore the weight that my learned friend sought to ascribe to it. And this is a submission just to explain what the learned judge said below.
And what about paragraph 87? Doesn't he say there that he or impliedly that he's not going to comply with it because he says it's fallen away in his...
Well, my lord, if I may say so, it's an extremely good point because it's totally contradictory. I mean, why would you say in one voice, the SPA has now fallen away because I've accepted the repudiation, and the other voice, but I'll just pretend that it's still extant and I won't compete. I mean, it makes no sense. I can't assist your lordship on that, I'm afraid, because it defies my understanding. Now, that's the first point, though, that the learned judge relied upon. The second point he relied upon, going back to...
Presumably you would say that the history shows that any statement by Dr. Ali wouldn't give you very much comfort anyway.
Your lordship has taken the words out of my mouth. My lord, I mean, and in any event, it doesn't say what my learned friend said it says. But nonetheless, Mr. Justice Bourne was able to elevate this to gone on the record for saying he will not do those things. Wrong. The next ground, and the second and only ground, that Mr. Justice Bourne relied upon was damages or inadequate remedy. That's paragraph 26. And that's a point that Mr. Justice Bourne appears to have made up himself, not in the pejorative sense. He came to that himself.
I mean, I don't think he made it up. I think it's quite well known that that's the second stage of the murky test.
When I used the word made it up, I wasn't using it in a pejorative sense. In the sense that nobody had suggested...
to me.
No, I withdraw that, absolutely. No one was suggesting, and my learned friend's going to try and show you, Lordship, where he was suggesting that an answer and a proper answer to these injunctions was that damages are an adequate remedy. Not in the skeleton argument, in none of the material before the judge. And the judge has decided that, in fact, damages would be an adequate remedy, and decided, for one reason alone, that Dr. Ali is a man of means. Last sentence, paragraph 26. Which, of course, doesn't address the point. The reason that damages in these cases are not an adequate remedy is for the reasons I've already explained, which I'd hardly need to explain to this court. So, we say very shortly that the grounds for non-continuation of the injunctions, the confidentiality injunction, as tweaked in the words proposed in the letter sent by Loch Lord that morning, were illegitimate with the greatest respect. And even let's say he had written a kind of in capital letters in an affidavit, in terms, I promise I'm never going to breach the covenant. Well, what weight could one give to those words? And as we say in our skeleton argument, if he's genuine about it, then there's no harm in granting the injunction. If he's not genuine about it, then there's every reason to grant the injunction. And here damages are plainly not an adequate remedy for the reasons set out in the learning, as accepted by Mr. Justice Constable. My lords, the way my learned friends seek to frame this point, and I'm cognizant of the time, is, and I will finish by one, as I know you never have to finish, but I will finish by one. The way my learned friends seek to respond to this, A, they don't make any reference at all in their otherwise full skeleton to the first reason. They just ignore it. And I understand why they do so, because it's problematic for them. As regards the second reason, they content themselves with two short paragraphs in their skeleton argument, for your lordship's benefit, paragraphs 70 and 71, simply saying, it's a finding of fact. Nothing you can do about it. The judge decided to make a finding that the damages would be an adequate remedy, and that's the end of it. They don't actually try and explain why. Of course, they're also in a difficulty there, and that's why they have to content themselves with a very short submission of para 70 and 71 about that. And of course, the fact that Dr. Ali is a man of means is nothing to the point. Doesn't meet the reasoning of the law of the judges over many decades as to why damages are not a remedy in these kind of cases. But instead, what my learned friends have to do is to try and recast the judge's reasoning by saying, in fact, the reason he declined to grant the injunction going forward was because of the breaches that he'd identified earlier in his judgment. But that's not what the judge decided, and there's no respondent's notice to try and uphold the refusal by reference to what the judge had decided as regards the discharge element of the injunction. And in any event, even if your lordships were willing to entertain the submission, everything I've said is applicable to that point, and I'm of course not going to go over the same ground. Now, my lords, there are two further points which are in issue. There is, my learned friends have put in a respondent's notice to say that my clients were in repudiatory breach and they accepted the breach, and your lordships can today say, yes, that's right, and can declare that a very substantial contract under which many millions of pounds have been paid has been brought to an end. And without pleadings, without an application of summary judgment, your lordships can decide that. Well, that's obviously wrong in my respectful submission. My learned friend Mr. Kinman was going to, cognizant of the diktats that emerged from the, I'm very keen to give my juniors time before the court, if that's convenient to the court. Mr. Kinman was going to deal with
You're going to give Mr. Kinman the last 5 minutes.
So I'm going to give Mr. Kinman the last 5 minutes. I have a fourth ground of appeal, but I suspect you understand that ground. It's a freestanding cost appeal, which I suspect I don't think I can improve upon. I'm certainly not resigning from it, but I just don't have time to open it orally. But everything is said, I think, that needs to be said in my skeleton. So I'm going to cede the court to Mr.
Yes, please.
To Mr. Kinman.
Mr. Kinman.
Thank you, my lords. I'll be as quick as I can, and within 5 minutes. Firstly, an important bit of context. Dr. Ali has received an awful lot of money under the SPA in return for the business which he's received. That I make it roughly £12 million. That's broken down as follows. £5 million by way of cash consideration, immediate cash consideration. That was coupled with a further £5 million, which he was entitled to draw out of the business. And then under the terms of the SPA, the purchaser novated that loan obligation such that it was owing from it to the business. So in effect, a further £5 million in cash. There was then, we say 1.4 million of what's called a holdback amount. The holdback amount was an element of the consideration which was variable depending on how completion accounts measured to various targets. Its maximum was 2 million. We say that he received 1.4 million of that. There may be a dispute as to whether or not some 600,000 is properly credited towards the holdback amount. I don't think that makes any real difference for the issues today. And he was also entitled to receive the earn-out payments depending on how he performed against certain benchmarks. And he received some 600,000 in respect of the earn-out payments, which brings the total to roughly 12 million. Dr. Ali now says that because we've not paid him 633,000, we're in repudiatory breach, and he's entitled to set aside the SPA and begin competing against the business that he sold to us for 12 million. Now, my learned leader has addressed you on why we say that the withholding of the 633,000 isn't a breach at all. I'm simply going to address the question of whether, if it is a breach, it's a repudiatory one. Just stepping back, it's a pretty unattractive stance for Dr. Ali to take in my submission. He says, I've sold you this, I've taken 12 million for it. Because less than 5% of that sum is still outstanding, I'm now entitled to damage the business which I sold to you. And it's particularly unattractive in circumstances in which the justification he put forward for his theft, as we characterise it from the business, was that it was in retaliation for us not paying him sums. It was effectively self-help, he says. So he says, not only am I entitled to help myself to the money that you haven't paid me, but also because you haven't paid the whole amount free and clear of any set-off, I'm entitled to set aside the non-compete and the confidentiality provisions. In terms of my substantive submissions on this issue, I just want to take the court to two authorities. The first will be very familiar to this court, I've no doubt. It's the Hong Kong fur case. It's tab 1 of the authorities bundle. The facts are that there was a charter party for 24 months running from February because the ship was provided with an incompetent crew. It was damaged and was in fact only seaworthy from September. So 7 months out of 24, the ship was worthless to the people taking the ship. And the court had to consider whether or not that was a repudiatory breach. And the court found that it wasn't. And the key question was posed by Lord Justice Diplock at page 66 of the report, page 44 of the bundle. He says, the test, whether an event has the effect or not, i.e. to be repudiatory, has been stated in a number of metaphors, all of which I think amount to the same thing. Does the occurrence of the event deprive the party who has further undertaking still to perform of substantially the whole benefit, which was the intention of the parties as expressed in the contract, that he should obtain as the consideration for performing those undertakings? And on the facts of that case, the fact that they had the ship for 70% of the time that it was contracted for didn't amount to, didn't mean that they didn't get substantially the whole of what they had contracted for. And on the facts of this case, Dr. Ali, as I say, has received the overwhelming bulk of the money owing to him. What's more, there are now proceedings, but at the point at which he repudiated, all we're saying is that we're going to set off the additional 633,000. So he would have still received the benefit of that money, albeit by a different means from immediate payment. And even now, he will no doubt claim that money gives him a defensive set-off or a counterclaim. So he has already received the overwhelming bulk of the money due to him. He will receive the economic benefit of any monies that remain outstanding to him. The answer to the question, has he received what he contracted for in return, substantially the whole of what he contracted for when he gave the non-compete and the confidentiality obligations, in my submission answers itself. Now, I'm conscious of the time. There's the second authority. Perhaps I can take the court to that in reply if need be.
Is your submission that we should not decide this point, or that we should decide it in your favour?
Thank you, my lord. The question for this court strictly is whether the judge erred in reaching the evaluative judgment rather, that there was a serious issue to be tried here. So the decision I urge the court to make is that there's no proper basis for interfering with that decision. That was a decision which was well within the generous ambit afforded to the first instance judge.
So all we have to decide is that the judge was right to say that there's a serious issue to be tried, and we don't decide it.
Quite.
We don't decide whether or not it's serious, and
No.
gosh, we got it right. We
No,
don't decide if it's serious.
Well, and the court doesn't even need to decide what it would have decided were the question before it at first
But the
instance.
judge was entitled to come to the conclusion that there's a serious issue.
Exactly, my lord.
Was this argument run before Mr. Justice Bourne?
Mr. Justice Bourne was invited not to continue the injunctions on the basis that there was no serious issue to be tried on this point.
Right. Thank you very much.
And don't take us to the second authority, but just tell us what it would have been if you'd had time.
I mean, it's right. I'm reminded by those instructing me that it wasn't taken in the application notice to discharge the injunctions. So insofar as this is a valid point, it's only valid in terms of continuation, not the discharge. The other case that I would have taken the court to is Valalilas and Januzaj. It's tab 21. It is, I apprehend, the case that Mr. Justice Bourne is referring to when he says that he was taken to authority, showing that the question's rather more complicated in circumstances in which there's been part payments. Taking the facts.
No, don't take the facts. I just wanted the reference.
Thank you, my lord.
Thank
you for
very
your
much.
indulgence.
Yes, could I just ask, it'll be Mr. Grant, I'm afraid, if we were to be in your favour and if we were to make an injunction going forward, I think you accept it would only be up to the 24th of March.
As regards the non-compete, certainly.
As regards confidential information, do you want to defend paragraph 3 of your schedule at page 17 of the core bundle? And if you do, how is Dr. Ali supposed to know which information might reasonably be regarded as confidential?
Forgive me, paragraph 17.
Page 17,
Yes.
paragraph 3. It may well be that that tracks the language of the contract, but if it's got to go in, and I appreciate this is not a point that's been taken, but if the court is going to make an injunction, the court's got to be satisfied.
My lord, I
have some doubts about it.
what I'm absolutely keen not to do is to try and create litigation positions. When this point was actually aired by my learned friend in his skeleton argument on the 13th of October.
No, I get all that.
What
I'm just
Lord
wondering
wrote back.
where we are now.
I would infer, because Mr. Siddle conceded that he'd erred in the schedule which you have at paragraph 17. I don't want to resile from that, and I would invite the court to make the order in the narrower terms that Locke Lord promoted on the 17th of October, which after all were in circumstances where my learned friend himself, even on the 13th of October, was saying my client is willing to offer undertakings. One assumes he's had enough time now to think about what the undertakings might be and whether or not my own form of wording is satisfactory to him.
Thank you very much.
Thank you, Lord.
Right, thank you very much, Mr. Grant and Mr. Kinman. Mr. Solomon, we'll hear from you at 2 o'clock.
Great.